Hello, I'm Stephen Wise. I'm a United States lawyer, and I'm president of the Nonhuman Rights Project, an organization that I founded 23 years ago. The Nonhuman Rights Project is a civil rights organization whose mission is to obtain fundamental legal rights, including the fundamental right to bodily liberty that's protected by habeas corpus, for at least some non-human animals. The Nonhuman Rights Project has been litigating the issue of the personhood and fundamental legal rights of non-human animals in U.S. courts by bringing to date 9 habeas corpus cases on behalf of imprisoned chimpanzees and elephants since 2013 in New York State and in Connecticut. Soon we will be bringing further habeas corpus cases in California and likely in Colorado. We also work with lawyers seeking similar sorts of relief for non-human animals in about 13 countries on every continent but Antarctica. I have written 4 books and 22 law review articles on this issue. Since 1990, I've taught animal rights jurisprudence at 8 law schools, including Harvard, Stanford, the University of Miami, and the Autonomous University of Barcelona. I'll be teaching this fall at Tel Aviv Law School. The legal status of every entity has been binary in the West since Roman times. An entity has long been either a person or a thing. A person has the capacity for 1 or 100 or an infinite number of legal rights. Things lack the capacity for any legal rights at all. On the one hand, persons have inherent value and exist for their own sakes. On the other hand, things possess merely instrumental value and exist for the sake of persons. In short, in legal systems, persons count in some fundamental way that things simply don't. Person has never been a synonym for human being, nor has personhood ever been merely a biological concept. The decision as to whether any entity should be a person, then, is really a decision as to whether that entity should count in some fundamental way. This court should utilize the available scientific evidence, existing moral and legal principles, including liberty and equality, and good public policy to determine whether any particular entity should be designated as a legal person. On one hand, this sort of analysis has long led to such artificial entities as corporations and ships being designated as persons. But within recent years, it has also led, for example in 2014, to the Indian Supreme Court designating every non-human animal in the entire country as a person, and to a lower Argentinian court designating a chimpanzee named Cecilia as a person for the purpose of habeas corpus. It has also led to this court designating a portion of the Amazon as an entity subject of rights, that is, a person, to the New Zealand Parliament and New Zealand courts designating a river and a national park as persons, to lower Indian courts designating a Hindu idol, a mosque, a river, and birds as persons, and to the Indian Supreme Court designating the holy books of the Sikh religion as a person. Alas, at times during the last 2,000 years, it has also led to African slaves, indigenous peoples, women, children, Jews, to sometimes being considered things. Much of the civil rights work of the last centuries has been occupied with slowly recognizing the dignity and personhood of every human being and painfully removing one human group after another, one at a time, from the category of legal thing to legal person. Legal personhood, then, is the foundation for every other legal right and the minimum necessary for any human being to flourish. All human legal history demonstrates that the only way in which even the most fundamental interests of a human being can be reliably protected, the circumstances under which any human being can hope to flourish, is through their recognition that they are legal persons. The reason is that their capacity to possess any other right necessarily depends upon their recognition of being persons. This truth was recognized by Article 6 of the Universal Declaration of Human Rights, which states that everyone has the right to recognition everywhere as a person before the law. By Article 16 of the International Convention on Social and Political Rights, which provides that everyone shall have the right to recognition everywhere as a person before the law, and Article 3 of the American Convention for Human Rights, which states that every person, there meaning human beings, has the right to recognition as a person before the law. Why? Because the guarantee of personhood is required to have any other legal rights. In May of 2018, writing in a habeas corpus suit brought by the Nonhuman Rights Project on behalf of a chimpanzee, Judge Eugene Fahey, who is an Associate Justice on the New York State's highest court, the Court of Appeals, wrote that, quote, to treat a chimpanzee as if he or she had no right to liberty protected by a writ of habeas corpus is to regard the chimpanzee as entirely lacking independent worth, as a mere resource for human use, a thing the value of which consists exclusively in its usefulness to others. Instead, we should consider whether a chimpanzee is an individual with inherent value who has the right to be treated with respect, unquote. There are a million species of animals, including oysters, ants, spectacled bears like Chucho, elephants, and chimpanzees. Not all species, perhaps, should ever be legal persons, and not all such legal persons should ever have the same legal rights. It's up to this court to determine, as a matter of good scientific evidence, moral and legal principles such as liberty and equality, and public policy, whether any particular species should be designated as legal persons. This first determination, then, should be whether even the most fundamental interest of a species, like Chucho's, should ever under any circumstances count. If it is possible that under any circumstances their fundamental interests should count, then they should be designated as persons, for this then gives them the capacity for legal rights to protect their most fundamental interests. Thus, this court may recognize that Chucho, who is a spectacled bear, is a legal person entitled to the fundamental legal right to bodily liberty that's protected by habeas corpus, which is a kind of flourishing, without committing itself to necessarily recognizing that Chucho has any other legal right. That is a second interdetermination, and it builds upon the fact that personhood is merely the capacity for rights. It permits legal rights to be given, but does not necessarily bestow upon a person any of the infinite number of legal rights to which he or she might theoretically be entitled. Thus, the question of which rights a person should be entitled to is a separate question from whether one should be a person entitled to any legal rights under any circumstances in the first place. This second determination should also depend upon the available scientific evidence, existing moral and legal principles, including liberty and equality, and good public policy, with the intrinsic nature of any species being one component, an important one, of this decision. Thus, Judge Fahey also wrote that the question is, quote, not whether a chimpanzee has the same rights and duties as a human being, but instead whether he or she has the right to liberty protected by habeas corpus. The answer to that question will depend upon our assessment of the intrinsic nature of chimpanzees as a species, unquote. For example, the Nonhuman Rights Project has determined that the protection of autonomy is a fundamental legal principle in many jurisdictions. In those jurisdictions, the Nonhuman Rights Project therefore argues that autonomy is a sufficient, though not a necessary, condition for personhood, and certain rights, and places before those courts sworn affidavits from the world's greatest scientists who have spent their professional lives studying the nature of the species, seeking personhood, such as our chimpanzee and elephant clients, that detail how those species are autonomous. This court may similarly seek better to understand whether spectacle bears, such as Chucho, possess fundamental interests, and not necessarily autonomy, that could be seriously and negatively affected by a denial of the bodily liberty that is protected by habeas corpus. Finally, a new legal concept that would protect the fundamental interests of appropriate non-human animals is not required. Personhood is entirely adequate, for it has a clear legal meaning that could easily be applied to non-human animals. A new legal concept would inevitably mean something less than a person. That would equally inevitably lead to the status quo of the legal thinghood of all non-human animals remaining unchanged, just operating under a different name, in which even their most fundamental interests, such as bodily liberty, would continue to be subordinated to even the most minor human interests. Thank you.